Okay. All right. Good morning, ladies and gentlemen. All right.
We call Dr. Richard Gilbert, Your Honor.
Dr. Gilbert. No.
Please face the court, raise your right hand.
Do you solemnly testify truthfully in this case under penalty of law?
I do.
Good morning, sir.
Good morning. Good morning, Dr. Gilbert.
Good morning.
Would you please state your name for the record?
Richard Stephen Gilbert.
And what is your...
I am an orthopedic surgeon. And I have a subspecialty training in surgery of the hand and upper extremity.
Dr. Gilbert, where do you work currently?
I currently in New York and Long Island at Northwell Health.
And you mentioned you have a specialty. Can you tell us a little bit more about what your specialty is?
So after medical school, I did an orthopedic surgery residency, and for a year thereafter, I did a hand and upper extremity surgery resident fellowship. And so my practice for them limited to surgery of the hand, wrist, and elbow.
And I think you may have gotten ahead of me there, but how long have you been practicing?
22 years.
Okay. What percentage of your practice over the past 22 years has involved surgery?
Approximately 1/3 of my practice.
Okay. And other than that surgery, what does the rest of your practice entail?
The rest of my practice entails a large portion of hand surgeons treat patients non-operatively.
In terms of the types of surgeries that you will perform?
So again, I limit my practice to hand, wrist, and elbow. I would say approximately 75% or so of my practice is limited to self. And this really varies from anything from conditions like carpal tunnel syndrome to tendinitis to injuries such as amputations, fractures, etc.
Over the course of your 22 years of practice, how many surgeries would you estimate you've performed?
300 to 400 surgeries a year, so a rough estimate would be approximately 10,000, maybe a little less.
Currently licensed.
In New York.
And how long have you been licensed in New York?
I have been licensed in New York since 1990.
And do you have any certifications?
Yes.
And can you tell us about those?
I am board certified by the American Board of Orthopedic Surgery. I have added qualifications in surgery of the hand from the American Society for Surgery of the Hand.
When did you receive your board certification?
2002.
Can you describe for us what current positions you hold?
I am currently an assistant professor of orthopedic surgery at Northwell Health, and I'm also the president-elect.
In what professional organizations are you a member?
I'm a member of multiple orthopedic organizations, including the Board of Orthopedic Surgery, the American Association of Orthopedic Surgery, and the American Society for Surgery of the Hand, as well as the New York Society for Surgery of the Hand.
Have you published any articles in your field?
Yes, I have.
Have you testified as an expert before?
Yes, I have.
Can you ballpark for us how many times?
10 over the past 22 years.
Your Honor, at this time, we'd like to offer Dr. Gilbert as an expert.
10 over the past 22 years.
Your Honor, at this time, we'd like to offer Dr. Gilbert as an expert in the field of orthopedic surgery, specialized.
So moved.
So, Dr. Gilbert, what work were you asked to do in connection with this case?
Medical records, radiographs, pictures, as well as testimonies and depositions of Depp's finger injury.
Okay. And to Depp's explanation of how his finger was injured.
He described the side of a bar.
Your understanding, what is Mr. Depp's explanation of how his finger was injured?
He describes that he was in Australia and his right hand, when a vodka bottle was thrown at his hand, injuring his right middle finger. And he describes that the vodka bottle exploded.
Are you aware of other explanations for that injury?
There have been multiple other explanations, but I think the one that was heard who believed that Mr. Depp was holding a landline and out of anger was punching it against the wall.
Based on your review of the medical records and other documents in connection with Mr. Depp's finger injury, how would you describe the nature of the injury to Mr. Depp's finger?
Well, the nature of the injury was he had what we describe as a comminuted fracture of the distal phalanx, meaning there was a fracture tip of the finger, and comminuted meaning that there were multiple pieces. So this is some type of blunt force with a high mechanism of injury. He also sustained loss of the tissue on the side of the finger towards the little finger. And this appeared, based upon my review of the pictures, to be some type of sharp laceration because of the edges of the wound.
Can we take a look at
edges of the wound.
Can we take a look at Plaintiff's Exhibit 60? Pull up to go to page 3. And Dr. Gilbert, are you familiar with this document?
Yes.
And what is it?
Two radiographs, x-rays of Mr. Depp's finger, his middle finger.
Okay. Sorry, just to stop you, but Your Honor, may we publish this to the jury?
Any objection? All right, we'll identify it as 60, page 3 in.
Sorry to cut you off
that's
there. Can you just tell the jury what we're looking at here in this X-ray?
Two x-rays of Mr. Depp's right. There's a fracture, again, what I described as a comminuted fracture, meaning there are multiple pieces at the tip. There's also a transverse component to the fracture.
In your view, what types of mechanisms can cause this sort of injury?
High velocity or force, generally a crush type injury. A simple fall would not result in a comminuted fracture such as...
Can we just define that quickly for us?
So again, comminuted, and it's not particular to a finger, is a medical term.
In your opinion, could this injury have been sustained in the manner Mr. Depp described?
I do believe so.
And how might a thrown vodka bottle produce an injury like this?
So a vodka bottle, which is a hard object, would have crushed the tip of the finger, resulting in the comminuted fracture. The vodka bottle broke, the glass would have lacerated the finger, resulting in the soft tissue loss that was also seen with this injury.
What's your assessment of the description of the cause of the injury offered by Ms. Hurd?
I think that's highly unlikely.
And why is that?
There's one, in general, when an injury is caused by punching against a wall or a hard object, it is extremely rare to see an injury of the fingers, which is seen with Mr. Depp's injury. Generally, you're holding something with a fist, and that in general leads to injuries most commonly of the knuckles here, or fractures of the metacarpal fractures. Second most common after those would be injuries to these, but as you can see, if you're holding something and hitting against something, it is very unlikely that it will be injured. In addition, just taking into account the radiographs and the pictures of the injury, I would not believe that a blunt force against a wall would result in the soft tissue loss.
What other injuries, if any, would you expect to see on Mr. Depp's hand if the injury had occurred?
So if that were the cause of the injury, you would certainly, that would be a dorsally directed, so this is the dorse in the back of the hand. Certainly, that would be a dorsally directed, so this is the dorse in the back of the hand. So if you're punching against something, you would certainly expect an injury to the nail. You would see either a loss of the nail or blood underneath the nail called a subungual hematoma.
In your review of the medical records, did you see any signs? In your view, is the injury, can you tell it consistent with Mr. Depp's description?
Well, which is a firm, resulting in, again, what I described as a comminuted fracture. And as Mr. Depp described, the bottle exploded, so it's certainly reasonable that the glass that exploded led to the soft tissue loss along the ulnar aspect of his finger.
Now, did you observe the testimony of Dr.?
Yes, I did. Yes, I did.
And he testified about Mr. Depp's finger injury as well?
Correct.
Right. Did you agree with Dr. Moore's testimony?
Certainly I did, yes,
Okay.
but not all of it.
Focusing on the parts that you, well, first of all, why don't you tell us what you agree on?
Well, I agreed in terms of his interpretation of the x-rays. He had a comminuted fracture, and this was some type of high-force injury.
Okay. What did you disagree with?
Well, I disagreed with several things. He does not believe that the mechanism of injury could be, as described by Mr. Depp, holding the hand on the side of a bar, because he said it was all a palmar injury, and there was a palmar component to the injury. I'm talking about the soft tissue loss, but there was also a dorsal. Actually, if you looked at the pictures which were shown when Dr. Moore testified, the injury goes like this. So it's an angled or an oblique. And there's no way that anybody could determine whether or not it was a palmar directed force, meaning from the palm side, or a dorsally directed force. They could determine whether or not it was a palmar directed force, meaning from the palm side, or a dorsally directed force. But certainly either are plausible.
Anything else come to mind that you disagreed with?
This was a pinching, or what he described as an avulsion type injury. And that's referring to the soft tissue loss. That certainly testified. The laceration looked fairly clean. There were clean edges. It was not jagged. And generally, when you have an imagine, as opposed to something that's cleaner, that would be lacerated by edges, it would not imagine, as opposed to something that's cleaner, that would be lacerated by, let's just say, a piece of glass or a knife or whatever. And that's more consistent with the pictures of Mr. Depp's injury.
And we're using the term soft tissue loss, and just to make sure we're on the same page, can you just tell very quickly what you're referring to there?
Right, so he, one, the fracture of the bone, and two, he had loss of the soft tissues so that the bone was exposed, so that amputated.
Now, you were saying that Dr.
Correct. Correct.
Why do you believe it's more likely that it was a laceration?
But the remaining tissue is usually very irregular. The borders are jagged, and that's not what.
Dr. Moore also testified that he thought a vodka bottle might not have sufficient force to cause the injury here. Is that your understanding of his testimony?
I certainly believe that a vodka bottle that was thrown from a distance against a hand that was resting on a marble bar is more than sufficient in this fracture and soft tissue loss.
Of his nail?
There was no injury to the nail.
And other than what you've already told us, how does that factor into your analysis, if at all?
It makes it highly unlikely that.
Do you have any opinion regarding the direction? Do you have any opinion regarding the direction of the injury?
Well, it's certainly, it's an angled injury, or what we call medically an oblique injury, because the soft tissue loss is at an angle. He lost some of the tissue on the back of the palm side, but other than that, you can't make any assumptions. Unless you saw a videotape of this injury, nobody could.
Dr. Moore also commented on the absence of fragments of broken glass.
Yes, I do.
And how does the absence of glass fragments,
If not, probably at least 500.
how does the absence of glass fragments factor into your analysis?
Probably at least 500 or more glass injuries, and I would say probably the majority you don't see glass in these injuries. It is common to see glass embedded in the wounds when you're talking about very fine glass. So if, just say a wine glass would explode or something of that nature, where you get little tiny shards. When you have thick glass, such as you see in a bottle or a pane of glass, you certainly can, but it's not surprising that you don't.
No further questions, Your Honor.
All right, cross-examination.
You're being paid $1,000 an hour for your work on this case, correct?
Correct.
And you agree, just to sum up how Mr. Moniz finished, you agree that the finger could have been caused by any number of things, right?
Yes.
And you're not offering an expert opinion on what you believe caused the finger injury, correct? A few times Ms. Hurd's account or Ms. Hurd's explanation, right? You remember saying that?
Yes.
You're actually aware that Amber has said she doesn't know how he lost. You're aware of that, right?
Yeah.
And doesn't know how he lost. You're aware of that, right?
Yes.
Yeah. You're aware that Ms. Hurd testified, and this was from your deposition. You're aware that she testified she doesn't know how he got his fingertip chopped off. You're aware of that.
Overruled.
No, I'm not. I reviewed the records, and in one of the testimonies that depositions that I reviewed, it was that potentially it was lost. Testimonies that potentially it was lost when he was punching against the wall with a phone.
And on that, the last point there, I think we agreed in this trial and previously that she saw him smash a phone to smithereens, a wall phone. You'd agree with that, correct?
I agree. I cannot speak for her, but yes.
Okay. May I approach, Your Honor?
Yes, sir.
You gave a deposition in this case on March 17th, correct?
Correct.
You were under oath in that deposition. You swore to tell the truth, correct?
Correct.
Okay, if you could turn to page 61, please. 4 pages per page of paper. It's on page 16 of the document.
Okay.
Okay, and line 9, you're asked a question, and then Amber's response to that question, that's the line, I did not see his finger go off. Question, and Dr. Gilbert, are you aware that Amber did not see Mr. Depp's finger go off? Answer, I mean, I'm aware that, well, I'm aware from reading, I'm aware of the mechanism that she claimed would cause the finger injury. Question, but have you read anything so far that indicates she doesn't know how the finger injury happened? Answer, from what I'm reading here, yes. Did I read that right?
Yes.
And you've heard no testimony in this trial from Ms. Hurd that the finger injury was definitively caused. And you'd agree that the fingernail was uninjured. You said that, right?
Correct.
And the nail bed was uninjured.
Correct.
Correct. But the area under the nail bed was uninjured.
Correct.
Correct. But the area under the fingernail, in the pulp of the finger, that's where the injury took.
It was not isolated to the pulp, no.
But it didn't injure the fingernail. That's my question.
Correct.
Okay.
Yes.
And under Mr. Depp's alleged theory, Amber threw a vodka bottle at.
Correct.
And you testified you have no way to determine the angle that the bottle was coming from.
Correct.
Right?
Correct.
Right? But she threw it on underhanded it, so it came up to his finger, right?
Correct.
And there's no way to tell, as you testified, what exact direction it came from, right?
Correct.
And the glass exploded, but you have glass in the wound, right?
Correct.
You haven't read any record of that in any medical record, the rest of his hand, correct?
Correct.
No bruising or injury on any other part of his hand other than the tip of his middle finger.
Correct.
And somehow, and his fingers, but didn't damage the fingernail while it amputated the area under the nail. While it amputated the area under the nail. Correct?
Correct.
And that is that you believe his hand must have moved at some point.
Not say that it did.
No, you believe that it did, don't you?
I said that it likely did, but I was not there, and I don't.
Let's turn to page 25 of your deposition, please. On page 25 of your deposition, please. On page 7. On page 7. Page 25 and 26. So it's page 7. Okay. Line 18. Question. And to be clear, by, quote, sitting in that position, you mean hand down, palmar side down. Palmar side down. Answer. That's what he claimed. History, yes. Question. And would it matter if Mr. Depp's the injury occurred? And as well, you can't determine if his hand had moved at some but. Question. And why do you believe that? Have you read anything in any of the materials to suggest that? Answer. No. Just that if it completely hit on the back, then he would have had a nail bed injury, which he did not. Did I read that right?
Correct.
That was testimony you gave under oath a month or two ago, right?
Correct.
So even though you have never, Mr. Depp's hand moved, his hand moving is the only way that you can fit your testimony into what Mr. Depp wants you to testify to, Kurt, isn't it?
No, that's incorrect.
Okay, that's what you testified to, that if his hand, for how Mr. Depp somehow suffered an injury that didn't injure his nail one bit, but injured underneath the nail. And that explanation.
I cannot make that assumption, nor can you.
No further questions. Thank you.
All right, redirect.
Dr. Gilbert, just very briefly, the absence of other cuts on Mr. Depp's hand, how do you factor that into your analysis?
I certainly can see an isolated finger injury with any type of injury, and I would say any other host of mechanism of injuries, you'd more likely see other, so that's an example. If you're punching against a wall, you would more likely see multiple injuries to multiple fingers. It really just depends upon how the bottle or impacted the hand at that point in time.
Ms. Hurd's counsel made a point of emphasizing that there were no bruises. Or how does that fact affect your analysis, if at all?
Well, it doesn't discount anything, but it certainly makes other potential causes of injury more unlikely, meaning punching against a wall or getting the hand slammed in a door.
And your discussion of Ms. Hurd's explanation of the...
No.
No further questions, Your Honor.
All right, thank you. Doctor, you can have a seat in the courtroom or you're free to go. Thank you. All right. Your next witness.
Plaintiff rests, Your Honor.
All right, plaintiff rests the rebuttal. Defendant counter plaintiff rebuttal case? Sure. Evidence.
Yes, Your Honor.
Mr. Murphy?
We call Mr. Julian Ackert.
All right. Mr. Ackert?
Do you solemnly swear or affirm to testify truthfully in this case under penalty of law?
Good morning.
Morning.
And can you please describe your educational background following high school?
I have a Bachelor of Science in Computer Science from the University of Virginia.
What is your profession?
Investigator.
Where are you employed?
I work for a company called iDiscovery Solutions, or IDS.
And what is your title? IDS perform.
IDS provides consulting, expert testimony, forensic analysis, data analysis, electronic data review and production services, ultimately.
What, if any, of those services performed by IDS have you performed?
I perform all of those services.
How many years of experience do you have in computer forensics investigation?
Worked in the industry for 20 years.
Can you please describe that experience to the jury?
I have experience creating and implementing data preservation and collection strategies, doing data collections, extracting data from collections, as well as analysis.
Physically imaging.
This would be any type of material that stores digital evidence. An iPhone, an iPad, a tablet, laptop, a cloud account, your Gmail account, anything that has...
Have you published in your areas of expertise?
Yes, I've published on data preservation and collection and analysis strategies.
Have you ever given any trainings or presentations in the e-discovery area?
Yes, I have. I do trainings and presentations to lawyers through continuous learning education.
What, if any, professional certifications do you have?
I have a EFE, that's the GX Certified Forensic Examiner certification, as well as you need to pass a test with a certain degree of, a certain percentage of passing.
Do you belong to any profession?
That is a group of legal professionals, judges, and technologists, and we discuss the intersection of law and technology issues in the legal community.
Have you previously served as an expert witness?
Yes, I have.
And when did you first serve as an expert witness?
I believe that would have been around 2009 was the first time I served.
Have you previously served as an expert witness in the field of computer forensics?
Yes, I have. I've been qualified probably a half dozen to a dozen times in both federal and state court, including this court right here.
Declined to qualify you as an expert witness?
No, they have not.
Your Honor, I offer Julian Ackert as an expert in the field of computer forensics.
No objection, Your Honor.
All right, so moved. Could you just spell your last name for me, Mr. Ackert?
K-E-R-T.
Thank you so much, sir.
Mr. Ackert, what is forensic imaging?
In a forensically sound manner.
And how is a forensic copy created?
Using specialized software that's available to forensic investigators, and that software may vary depending on the device, like a phone or a laptop.
What type of information does a forensic image collect?
It's going to collect your documents, your emails, your photographs, your opened or looked at on the laptop, as well as all of the metadata for these different types of electronically stored information. They're looked at on the laptop, as well as all of the metadata for these different types of electronically stored information files.
And does any other information accompany that information that's collected?
Forensic imaging, you're also going to get log files. Log files are files that help you validate the forensic image and verify that it was a forensically sound data collection.
And how do log files enable you to
List information within the files. Sometimes they're even embedded within the images themselves, but they provide verification information that allows.
Purpose of creating a forensic image of devices or data?
In order to extract and analyze data forensically for the courts, you need to create a forensic image of the data first and gather the forensic image.
And what, if any, specific types of data are collected in that image and extraction?
It's going to be any type of data that comes from the image, whether you're extracts or documents or spreadsheets or anything of that nature.
Do you recall Mr. Neumeister mentioning the term hashing yesterday?
Hashing is essentially a digital fingerprint of a file. Every file, a digital fingerprint, essentially, and identifies the uniqueness of the file.
And what, if any, applicability does hashing have to the visual appearance of data?
with the visual appearance. For example, if I had a Word document that I printed and then saved, therefore I haven't visually changed the Word document, the metadata of that Word document indicate would be different, and therefore that Word document would not hash to the version that I used before printing.
Can you give any examples of digital photographs that visually appear the same?
I believe Mr. Neumeister included 3 of those in his demonstratives yesterday, 3 side-by-side photographs that looked visually the same but did not hash. It made sense that they wouldn't hash different file sizes. And a file size can change for a photograph depending on what you do with the photograph. So for example, maybe you want to take that photograph and email it to somebody, and on your phone, you choose to medium or large or different size of the photograph when you email. When you send that email with that photograph, you've changed the hash value because you've changed the 1s and 0s because you've changed the size of the photograph.
And what, if anything, do you recall?
Some metadata for files. There's the embedded metadata, which is what we're discussing here, the EXIF metadata and external metadata. And Mr. Neumeister was the software version that the file last ran through was Photos.
What is Photos? What is Photos 3.0?
Photos is actually the software application that's built into the Apple operating system for laptops. This is the application that launches by default when you're on an Apple computer, and use Photos.
What are the capabilities of Photos 3.0?
Abilities for it, you can, for example, create an album with it and put multiple photos within an album. You can organize or sort your photos by date and time taken or place. You can also use photos.
You mentioned metadata earlier. What is that?
Metadata is information about a file. For example, with a document, who saved it, who was the author of the document. For photographs, metadata includes information that you've seen on demonstratives before, including when was the image taken, what kind of phone took the image, used for that image. Any type of information inside the photograph, the EXIF data that you've heard is metadata.
Did you form any opinions in response to Mr. New's software EXIF metadata field?
Yes, I did.
And what are those?
My opinion is that for each of the original photo that did not have photos in the EXIF metadata. In other words, those are the photos that he was indicated he would have expected to see the iOS or the phone software version.
How do you know it is an original version of the photograph?
This is a little bit dependent on the Apple ecosystem. Amber, synchronize your information from device to device. So for example, if you take a photo on your phone, you see that experience. Apple wants you to be able to see and visually have the same experience on all your synchronization process. It does not affect the metadata that we're talking about here, which is the embedded metadata. That means that the photo was not saved using the Photos application.
And what, if any,
collected or were collected for Amber, including mobile devices, tablets, laptops, etc.
Michelle, can you please pull up defendant's? Do you recognize this chart, Mr. Eckert?
I do.
What is it? Without.
This is a chart I created as part of my report.
Do you recognize this chart, Mr. Eckert?
I do.
What is it? Without yet saying what the content.
This is a chart I created as part of my report.
Your Honor, permission to publish defendant 671 is a demonstrative. Mr. Acker, can you please describe in more detail what the information in this chart is? Mr. Acker, can you please describe in more detail what the information in this chart is? And Michelle, if you could just stay at the top for a quick second.
Its report and the items that I found on Ms. Heard's devices that did not indicate for the original software metadata field of iOS.
And do you see the second column titled Neumeister Report Date Captured?
Yes, I do. This is the date time metadata of the particular photo on Neumeister's report. So for example, the first row, 23, the date time captured, or the date captured is December 16th, 20. Second row, 24, you see that the date time is May 21st, 2016. Third row, May 21st, 20.
Please, Michelle. Please continue for the items on this page.
The top row of this page, the one that came from Neumeister's report, page 30, shows 2016, and then finally 32 shows March 23rd, 2013.
Do you see, can you scroll back to the top, please, Michelle? Do you see the top, I'm sorry, the right-hand column of this chart?
Yes, I do.
And where it says device ID and file name?
Yes.
Can you please explain what the information in that column means for items identified from Mr. Neumeister's demonstrative?
So these are the evidence IDs and evidence ID matching file name found on that evidence ID that indicated the original version of this same photograph that Neumeister identified that did not show photos in the software metadata, iOS version in the metadata.
And what do the little A's followed by numbers, backup, what does that mean?
Those are evidence IDs. Anything that starts with a backup and follows by another number is an iTunes backup.
So what, if any, what you have here are iTunes backups?
Only the ones that start with the word backup. Even the ones that start with an A number are actually an iTunes or an up to iCloud. And those are coming from an iOS backup at iCloud. Everything else is coming from an actual physical device.
Defendant 1675. And without yet getting into the contents, can you please describe generally what it is?
This is a chart that I prepared as a summary of my findings.
No objection.
This is a chart that I prepared as a summary of my findings.
Permission to publish defendant 1675 is a demonstrative.
No objection.
All right, 1675 will be published as demonstrative.
Evidence ID. So for example, A001 was an iPhone X of Amber's that was collected. A002 was an iPad of Amber's collected. I'm sorry, A11, 12, and 13, slightly down, are 3 different laptops that were collected.
See the source type column?
Yes, I do.
And the source details column?
Yes, I do.
Can you please describe what those columns mean?
Generally, the ID evidence number is the evidence number that we assign evidence, and the type and details come from a description of that type of evidence based upon the collection set.
And Michelle, can you please do a side-by-side of 1675 and 1671? So, Mr. Acker, can you please describe the relationship between these two demonstrative exhibits?
Certainly. If you look at 1670,
between these two demonstrative exhibits.
Certainly. If you look at 1671, the one on the left, you can see in the fourth column different evidence IDs where I identified the original versions of those same pictures that Mr. Neumeister had specifically identified and the sources of where they were identified. Look at the first one, for example, that do not show the software EXIF metadata field of photos. Rather, it shows the original iOS version. 02, which is Amber Heard's iPad Pro. Scrolling on down through there, you see it on A0011, which is Amber Heard's laptop. Same with A0012 and 13. You can see this again with the next row that's visible at the very top. Neumeister identified EXIF metadata of that, showing the ad. And it's not surprising to me that I found all these on all the devices because that's how the Apple ecosystem works. It replicates your pictures or synchronizes your pictures across.
Mr. Acker, you can take this down, Michelle. Do you recall Mr. Neumeister's testimony regarding what he claims of EXIF metadata modification?
Yes, I do. This is a completely Mr. Neumeister never specified any pictures with specificity that had EXIF metadata modification, and it's a hypothetical in my opinion.
Mr. Acker, did you form any overall conclusions in this case?
Yes, I did.
And what were those?
The images that were included log files that allowed me to validate and verify the evidence collected. I validated and I found photos that he had concerns about, specifically the ones that had iOS in the software metadata field. I validated that those came from devices files that were validated by me. In other words, they came from original evidence files, and in most instances, they came from...
By to today made to a reasonable degree of forensic certainty.
Yes, they are.
No further questions, Your Honor.
All right. Cross-examination, sir.
Good morning.
You've worked with...
All right. Cross-examination, sir.
Good morning.
You've worked with opposing counsel's law firm approximately 20 times before?
Give or take, yes. Those 20 probably would have been spread out over more than a dozen years.
That all of the photographs produced by Ms. Heard are authentic originals, correct?
Now, I can testify to the ones that Mr. Neumeister identified with specificity.
Thousands of photographs provided that Mr. Neumeier didn't testify about, right?
I have no opinions on any photographs.
So as you sit here today, can you testify that all the photographs produced by Ms. Heard are authentic originals?
As I sit here today, I said have not been presented to me that are not authentic originals.
Right?
Yes.
Yeah, you just talked about it, right?
Yes.
Right. And you'll agree with me that the XF data of some of the photos reflect the use of a photo editing application.
No.
No?
I'll agree that they show the use of the Photos application, sorting and editing application.
Okay, so what you were quibbling with is, are you prepared to swear under oath that each and every photograph provided by Ms. Heard and entered into evidence in this court,
Based on the metadata that I have reviewed of the specific photographs I have reviewed, originals?
no, I'm asking you a broader question than that. There were multiple photographs that Ms. Heard provided that were entered in that. There were multiple photographs that those are each authentic originals.
I have no testimony or opinion on those because nobody's provided me opinion that they're not.
Okay. Defendants Exhibit 712 and Defendants 713 next to one another.
Okay, if they're admitted, we can publish.
Can you see this, sir?
Yes, I can. Visually,
Can you see this, sir?
yes, I can.
You'll agree with me that those are different pictures?
Visually, they look different to me, yes.
All right. We can take that down. Mr. Gibson, pull up Plaintiff's Exhibit 1308. This has not been admitted, Your Honor, and I propose to use it.
Any objection?
Not as a demonstrative, Your Honor.
All right. Be identified and published to the jury.
Any objection to entering it into evidence?
I would object it's cumulative, Your Honor. Actually, no.
Mr. Gibson, can you blow up the time, date, and file name? Sir, you just agreed with me that those two photos are different photos, correct?
I agreed that they were visually different, yeah.
The exact same minute, the exact same second, and the metadata shows something else too. They have the exact same file name. How would you have this jury decide?
Recall.
How would you have this jury decide which one is real?
I think you would need to look at the software metadata field. Recall if I looked at for this particular field, but I think that's what even Mr. Neumeister said, that you need to look at the software metadata field.
But we have two that have the same identifying information, but in your view, look visually different, correct?
Our metadata field here.
I look visually different, correct?
I don't agree that our metadata field here.
The identifying information includes the hour, minute, and no further questions.
All right. And just for the record, since we already have 712 and 713 in evidence, are now in evidence, just to keep the record clean, okay?
Inside a file. I talked earlier about the date printed of a Word document. That's embedded into the file, and that traverses with the file wherever it goes.
And based on all reviewed, do you have any reason to question the forensic authenticity of any photos Mr. Neumeister testified to for which you were responding to?
Can you repeat that question?
Based on all of the photo metadata you have reviewed, based on the photos Mr. Neumeister testified to. Do you have any reason to question, Mr. Ackert, have any of your opinions in this matter changed?
They have not.
And is it still your testimony that the opinions you testified to do today are made with a reasonable degree of further questions, Your
All
Honor?
right, thank you. Sir, you can have a seat in the courtroom or you're free to go. All right, your next witness.
Your Honor, we would like to call Dr. Don Hughes to the
All
stand
right,
again.
Dr.
I'm a forensic psychologist. I am board certified over 6 visits for
Curry said you used improper methods. Would you?
procedure that is well established in our data to arrive at an opinion, and you're looks where it seems that Dr. Curry seems confused. Was most notably done in a criminal court for instruments are not linked to a specific legal criteria. A malingering measure that I utilized was the MFAST, and that was the only validated and well-researched and used in the clinical realm as we understand people MMPI, and used in the clinical realm as we understand people MMPI, the PAI. The reason that we do that and we use these clinical measures is because the majority of the people that we see are in a clinical realm. Also do is use a very different types of tests with interviews. We use structured clinical interviews, and then we look for the consent. Go about these tests in the
All of these different tests. Is that accurate? Different tests. Is that accurate?
all the time, frequently, and that is not how she endorsed these tests.
Now, Dr. Curry also suggested that Amber Heard was tested very, very high, 98.
I mean, she said a lot of things, so let's go through those tests. The first was the PAI, and that's that
PAI test that Dr. Curry
yes,
addressed.
so yes, test. I told you last time that there was no evidence of malingering or exaggeration or feigning on that test. What determines faults on this PAI? That scale was a serious response distortion, of which Dr. Curry was saying, on traumatic stress, on height test, and this test.
Objection, Your Honor.
Specific-
May we approach?
Yes.
On that, did you agree with her testimony yesterday?
No,
Please
again,
describe why. Explain why.
what Dr. Curry went back to, which is this 98th percentile, which manual, all you have to do is read the manual. It says specifically that we do not, and then she then is therefore not qualified to interpret it. That score, the one that's elevated, which she's talking, which she's talking about, that percentile rank, has always a 15. She's nowhere near that level of exaggerated, a little more on the TSI that were elevated. Intrusive experiences, that's when thoughts and memories of the trauma come into your mind when you don't want them about them. And then relational avoidance, a way of having difficulty in interpersonal relations.
Thank you. Dr. Hughes, the MFAS, Dr. Curry addressed that as well and had criticisms for
The measure of malingering. It's the only measure of malingering that was done in this case. Dr. Curry kept saying something that MFAS is not for malingered PTSD. That's wrong on a couple levels. People who are going to malinger and feign don't only feign one talk about all different symptoms that they have, and they exaggerate and they make themselves seem much worse than they are. So when you're doing an evaluation, you're giving a malingering measure to how this person is responding to this evaluation. Now, what you do is greater confidence in your results. And that is in the literature, and that's literature that Dr. Curry cited in her report. That bolsters the methodology that I used. That it had the PAI, the MFAST, and the TSI in the title of detecting feigned from bona fide people.
appropriately interpreted that. Do you agree?
That's also incorrect.
Please describe for the jury.
Or lethal domestic violence. Those risk factors exist whether we go forward, we're sitting with someone in an acute setting and assessing them right now, or may have been present in a case that indicated severity. That instrument is used, has occurred in a domestic situation. They look at these risk factors to see what was there and what could be done.
All right. Dr. Curry also, do you agree with her criticisms?
I do not.
Will you please explain to me?
Yes, I'm moderate, severe, and extreme. All of hers were, I mean, we don't want someone to be having moderate PTSD, but that's not an exaggerated profile.
Dr. Curry referred to as the PCL-5. Do you agree with her criticisms of your administration and interpretation of that?
No, so the PCL-5 is a checklist of symptoms of PTSD. That it is a face valid instrument. It means it's very clear about how you can endorse this. But what the person has to do is say, how with these other measures that have the built-in sort of ability scales, you're sort of controlling for that response bias error. You're controlling for that. But then what you do with that test, because this is, you know, we're not just administering them like robots, January of 2021, and I did a clinical assessment of those symptoms to see if they meet criteria for PTSD. That is something we do clinically, and I did PTSD from that in January 2021.
Thank you.
Yes, she did meet PTSD.
Now, Dr. Curry said you misinterpreted her.
She misinterpreted them.
Okay. And please explain.
Yes. So I said that I believe wrong, and I think most...
Objection, Your Honor.
All right.
That's the issue we just addressed.
All right.
Now, Dr. Hughes, Dr. Curry also testified that a victim...
The evidence.
She said they couldn't hike, they couldn't move, they couldn't function in any...
Conception about individuals who were struggling with PTSD. Courageous, resilient people, even though that they're struggling. They get up about it as they're sort of walking around with a 50-pound bag of flour on their back and have startle and have physiological reactions. If you have someone in that high range, the highest score is an 80, that's not the norm of people who have this moderate PTSD.
And did you find functional psychologists to evaluate domestic violence? Do you agree?
Specifically trained to understand the profound impact that trauma has on people's lives. That's what is one of those profound traumas. Domestic violence is part of state licensing boards, that you can't get licensed in some states unless you take training on domestic violence. So people who have, specialized training in this area, it is, beholden upon them to act. More important to assess for this sort of scientific understanding of what domestic violence is. So you have to assess for the emotional abuse, and the sexual violence. That is not gratuitous.
Now, Dr. Curry suggested that you made a determination just based on personal opinion and just on checklists and a couple of tests that you...
Vehemently disagree with that. As I stated to you, over 29 hours and 12 psychological tests with therapists, using all that data, that is what a solid forensic methodological exam looks like. And then I made my training to come up with a professional expert opinion.
And just to remind, in forensic psychology, specifically in domestic violence and in the violence, correct, intimate, and in trauma. correct?
Right, I believe
Objection,
it-
Your Honor, misstates.
I gotta find my note. You were qualified as an expert in forensic psychology with a specialty in violence and in trauma, correct?
Correct.
Okay, and that was in this case.
That's correct.
Okay. Now, do you still hold them within a reasonable degree of psychological?
Good morning, Mr. Dennison.
The last time you were here, before you gave the gold standard CAPS 5 test.
That's correct.
Right. And that diagnosis, disclosures you put forward in this case.
I believe the first disclosure was
And your disclosure reads, Ms. Hurd's responses on the PC with an etiology of intimate partner violence she experienced by a former partner. You remember writing that? That you need to read the manual, right?
yes.
Okay. Can we put up 1311 as a demonstrative?
Any objection to
I don't know
1311?
what it is, Your Honor.
All right, if you want to
May we
leave,
approach?
you want to approach?
Tom,
Thank you.
let's use 1312.
1312, okay. Be published to the jury.
Dr. Hughes, do you recognize what the National Center for PTSD, the PTSD checklist for DSM-5,
That's correct.
that what we've been calling the PCL-5?
Correct.
All right. And do you, on your screen,
Yes.
all right. What is it?
It's the instruction manual.
Mission of 1312?
Any objection to 1312 coming into evidence? All right, 1312 in evidence.
All right. Can we go to the second page? Can we blow up the second paragraph? The PCL-5 should not be used as a standalone diagnostic tool. Considering and a recommended structured interview, e.g. the CAPS 5.
Right, and this manual
Okay.
also says that this is a screening instrument, so when you do the clinical, which I used,
Well, let me finish my question.
it does say that, yes.
Yeah, and you made your diagnosis before you did the,
Diagnosis of PTSD and symptomatology. Sure.
okay. Tom, can you pull up 1309 as a demonstrative?
Yes, sir. Thank you.
May we approach?
Okay.
Doctor, do you recognize, so this, what do you recognize this? What do you recognize this as?
She was already out of the relationship.
Okay, maybe we should back it up. You did it in relationship to your diagnosis.
Right, this is the conflict tactic scale too.
All right. And you'll agree with me Specifically asks in front of every single question.
To not limit herself to the last year to get an accurate assessment of the violence and abuse that she experienced in the relationship.
Objection, Your Honor, move to strike.
That's part of the answer. Thank you. Next question.
For far longer than a year, correct?
Which is why I oriented her to a different
Yes or no,
time
ma'am?
frame and answer.
Let's look at another one of these. You talked about the danger assessment test.
That's correct.
All right.
Any objection to 1310 as a
No, Your Honor.
demonstrative? Okay. You publish to the jury.
Dr. Hughes,
Now based on the data that was provided to me.
oh, so you asked a paragraph? It says, using the calendar, please mark the approximate dates during the past when you were abused by your partner or ex-partner.
These are static risk factors, so they don't change. So
But
I
these
oriented.
specifically indicates that that you were supposed to look over the past year. And that's not the language?
No, that's one administration. If you're in an acute situation in a relationship, trying to get a better assessment of the current behaviors, we can use it retrospectively, like I just stated, and in homicide, serious risk factors that were in this relationship.
I didn't ask you.
This test, not only on the
Nope,
previous year.
asking you about the instructions.
But I'm telling you how the test is administered in clinical practice and in forensic practice.
And the instructions say, look over the past year for this test.
That is correct.
Right. All right. Let's look at more instructions. All right. This is what everybody calls the CAPS 5.
Correct.
All right. Can we go to the first page? Standard administration and scoring of the CAPS 5 are essential for producing reliable and valid scores and diagnostic decisions. Correct?
Correct.
And you know you have to do this in a standardized way because it is the first instruction, correct?
Correct.
One more. Oh, wait. That's good. This is a page on scoring and frequency and intensity.
Correct.
And you'll remember that you failed to do so, correct?
That's not correct.
Oh,
The caps where I am actually scoring the caps.
no,
Where
I asked
it's
you whether
relevant.
you filled in a... All right, let's page down. Let's keep going. You're asked to fill in as to, I think, a fairly fundamental question, right? What happened?
It would have been redundant to put it there.
You know that you are obligated to produce this test in a way that other people can meet.
Or meaningfully reviewing them have my 88 pages of notes.
Right. But you that said what happened.
You don't have to put it in the, if you're using it for a clinical diagnostic purpose, no, you don't. If you have that data elsewhere.
Okay. Let's go another page. All right. Let's go another one. And I asked you whether you filled in the blank about frequency. And there's a blank in asks number of times. You believe that you follow.
You used the term static risk factor. What did you mean by that?
Static risk factor. If you smoke cigarettes, you may have a risk of lung cancer, right? That's a factor that doesn't change. You can look evaluating them in the last year or 5 years ago.
And when you're trying to assess for why is it important to get a time frame in which the relationship was in existence?
That they're in a relationship, you have more successive trauma, and one of the things that we know from the research is more trauma is not better. Consequences and symptomatology as a result.
And therefore you need to get it within the relationship.
Objection leading.
And so how does that relate to needing to get the relationship?
Well, you need to understand the when you're trying to evaluate the impact of something, you have to understand care and of trauma diagnoses. You have to understand, the traumatic event. And
You had 88 pages of notes. What were in your 88? And without going into the specifics, can you just
many of the documents.
say what was in your 88 pages? I'm not asking her to give each of the specific events. She can describe the clinical evaluation and research evaluation with respect to the compounded, because it might be confusing to the jury.
Good. Sustained. Next question.
Okay.
Objection, Your Honor, compound.
Overruled.
88 pages of notes to help understand the background of the trauma into the computer. And then they would maybe look at some of that data for the research study. So that becomes very important.
Courtroom where you're free to go, okay?
Thank you very much.
All right, ladies and gentlemen, let's go ahead and take our afternoon recess. Our morning recess. All right, are we ready for the jury? Yes, ma'am. Water. Water.
This time, we're in the rebuttal to your counterclaim against Mr. Depp. So I'm going to confine me as a result of the Depp woman's statements.
Humiliated, threatened, sitting here in front of the world, having the worst parts of me. People want to kill me, and they tell me so. Threatened every single day that I lived.
Objection, Your Honor, non-responsive.
How did Mr. Depp's statements and threats to you that you were discussing, how do those continue to manifest themselves today?
In the harassment and the humiliation, the campaign in this room. Every single day, I have to relive the trauma, to live with a set of unspoken rules about how to not scare me.
Objection, hearsay.
Me, not to surprise me. My gynecologist I see. I live my life with these sets of rules. Even if I'm training to do my movie, for instance, if I'm training, the crew I work with have to deal with that because of the damage. I walk in the room laughing, smiling, and making snide jokes. I'm not. And perhaps it's easy to forget that, but I'm a human being. And even though Johnny promised that I deserve this and promised he'd do this, I want to move on. The statements to do on his behalf when he himself
Objection, Your Honor,
couldn't do
lack
it.
of foundation.
It's impacted your ability to do charitable work.
You know, people like Dr. Curry can sit up here on the
Your Honor, Mr. Depp gave long-winded responses.
trauma until I realized I could do something with it. So to answer your question, Ben, I into work, into action, into providing a voice for other people. I'm not a saint. I'm not trying to, and being able to use what I've lived through to advocate for others. And on my worst enemy, if it gives a voice to someone who's with me because of the threats and the attacks that they have to endure.
Objection,
when they are.
non-responsive.
What threats have you endured since the Depp-Waldman statements were made?
I receive hundreds of death threats.
Objection,
Agonizing. I hope no one ever has to go through something like me alone. I just want him to leave me alone. I've said
What do you...
protecting the secret that I did for as long as I did. Voice. I have the right as an American. I hope to get my voice back.
All right, cross-examination.
Ms. Heard, you just testified that this case has been very hard for you, right?
I haven't lied about anything I've been here to say. Risk by saying he knew how many pounds of pressure, or asking her how many pounds of pressure it took. I'm not quite sure what part of that night. There were a lot of people there that night.
You testified that once you brought Mr. Depp back to your trailer, he trashed it. Do you remember that testimony?
That's correct. Work to be involved.
So you're accusing Mr. Knight of testifying. Might testify that it was actually you who was upset with Mr. Depp spending time away from Mr. Depp. Isn't that correct?
Again, I've heard a lot of people say a lot of things to be involved in the Johnny Depp show, but he wasn't there. He doesn't know.
So you're calling Mr. Knight a liar?
I am.
Heard? Did you hear that?
That's his testimony, yes. He testified that a light fixture was broken, similar.
Was a light fixture, yes or no?
I realized that he summed it up.
And after he summed it up, testified that he charged Mr. Depp only $62 for the damaged light fixture. In Hicksville, you were the one who was upset that Mr. Depp wasn't giving you enough. 27th, 2016. Do you remember that testimony?
I said I did.
No idea that the press was going to be outside after you got the ex-party TRO.
I had no idea whether they were going to be there or not. When I walked into the courtroom that day, it was completely quiet, still. No reason to believe the press knew.
And Your Honor, I would also ask that you instruct the witness to please stop talking once I lodge an objection.
Your Honor, she's trying to answer the question as best she can. And Ms. Vasquez.
We'll strike the last part as non-responsive. Just if you could answer the questions asked. Okay, thank you, Ms. Heard.
You weren't shocked at all, though, were you?
Incorrect. It was.
You knew the
horrifying.
press would be at the courthouse.
I sure did. I'm a public figure. I brought my publicist in case it blew up. In case. And
You actually
I'm glad
had
I did.
alerted TMZ that you would be filing a TRO against. One day, you didn't bother to wear makeup to cover up the mark on your face.
I did not call TMZ.
Correct?
Did I hear his testimony?
Yes.
Yes, I was here.
Yes. And you heard Mr. Tremaine to the courthouse to capture a picture of an alleged bruise on the right side of your face. Do you remember him saying that?
I remember him saying that.
That information must have come from your team, right, Ms. Heard?
Absolutely. That what actual survivor of domestic violence wants that?
Now, the video of Mr. Depp beating up some kitchen cabinets, you admit that you took before you were deposed in connection with your divorce from Mr. Depp, and you testified that you learned about it when you landed after flying into LA. Do you remember that testimony?
Upon touchdown is yes, I did.
And you heard Mr. Tremaine testify that TMZ received the cabinet video the same day you landed at LAX. Yes?
I don't know if that.
Mr. Tremaine testify that the cabinet video was posted 15 minutes from the source. Yes?
I heard him say that. I don't know if that's true or if that's possible.
Another liar on the stand?
I just know that that's incorrect.
Right. And you heard Mr. Tremaine testify that TMZ owns the copyright to the cabinet video, your then husband. Yes?
The copyright ownership of that is news to me. I learned that yesterday. And yes,
cabinet
that was
video,
my husband.
The same cabinet video that was released the night before you were deposed in your divorce. Yes?
That's correct.
Okay. You must have also heard Mr. Tremaine's cabinet video that TMZ received was incomplete compared to the video the jury saw in this trial. Did you hear that?
The video that the jury, that you have seen.
Right. But the one TMZ got the day before your deposition in the video that TMZ received.
I don't know what video TMZ.
I'm sorry.
Yes, I heard his testimony. We all did.
And he testified.
I disagree with that.
Was also not included in the TMZ video.
Everyone can watch. It did not come to me. Come from me.
Ms. Heard, you edited out the portion.
Way a lot sooner and a lot more.
Because you
I was
knew exactly
living
how
with
to
a
do
mountain
that, right?
of this evidence. If I wanted to leak it, I could have done a lot more with it.
Remember
I don't.
that? Gave it to TMZ. Domestic violence restraining order against Mr. Depp, right?
It is.
And next to you is a woman, 1316. Your Honor, I'd like to move to admit this photograph.
Any objection to 1316?
No, Your Honor.
The jury?
This is a picture of you on May 28th, 2016, right, Ms. Heard?
I don't know when this was taken.
This is the day after you obtained the domestic violence.
I have no idea when this image was taken. I did not take it.
There's no bruise on your face in this picture, is there?
No idea when this was taken, so I have no idea if I can
Let's
speak to
refresh your
what
recollection.
bruise you can see
Let's
or
refresh your recollection about when this picture was taken. This is an article dated May, and the article is entitled, Amber Heard Smiles as She Puts Arm Around Friend One Day After Getting Restrained. I'm going to move to admit and publish the article with everything but the headline and date and the photo redacted.
All of these.
I'll sustain the objection. All right, next question.
Picture of you and Ms. Pennington on May 28th, 2016, isn't it?
I don't know when this photo was taken, but it looks like the same outing as the picture prior.
Your Honor, I'm going to move to admit and publish.
Any objection?
No, Your
All
Honor.
right, 1317 in evidence, you can publish.
Was taken, then obviously there's a bruise on my face. It's covered by makeup as per usual.
Let's zoom out of that picture for a moment, please.
That is correct.
In there too?
That
Ms.
is
Pennington
correct.
submitted a sworn statement on your behalf in support of your domestic violence restraining order, didn't she? Mr. Drew also submitted a statement in support of your domestic violence restraining order. Testimony. You testified that this was taken in the downstairs of the main apartment on December 15th, 2015. Do you recall that testimony?
Yes, I believe so.
Testimony that Defendant's Exhibit 512 reflects damage to Penthouse 5 that occurred during...
This is when I see this photo in a vacuum without context.
Let's give you that context. Can we please, thanks, if I could have day 16 trial testimony? First to page 4585. Specifically on, starting on line 16. 4585.
Pardon.
Line 16. Where it says, let's talk about December 15th, 2015. Do you see that?
Yes.
Okay. And then do you see that your testimony about December 15th?
First line or two. Yes.
Okay. Now I'd like you to turn to page 4603, line 12. 4603. Starting at line 12 and going on to page 4604, line 4. Evidence Exhibit 512, which is on the screen,
Yes.
is a picture of the downstairs of the main...
The main apartment's penthouse, the mezzanine office was in between.
All right, so it's your testimony
From, again,
in
in my
relation to that incident.
Sorry, go ahead. What?
In relation to that incident on December 15th, 2015. Put it into evidence in this court. You testified that this was the result of damage that occurred on December...
Partial
No,
picture of a
Ms. Hurd,
floor,
you didn't just
so
look
I
at a
can't.
picture. You looked at your testimony.
You
Pull up, let's actually leave up Defendant's 512 and please pull up Defendant's Exhibit 7.
All right, thank you. You can publish.
Just side by side. You've seen this photograph as well, right?
I have.
Penthouse 5 on May 21st, 2016, didn't you?
Again, I don't know because I'm looking at a partial picture of a floor. So unless you remove the
I didn't cover it 21st, 2016. I didn't cover it up, Your Honor.
Could we unredact
Your Honor
them so we could get
it up, Your Honor.
Could we unredact
Your
them?
Honor, if you wouldn't be making argument to the jury.
Sorry, I
It's
thought you had
inappropriate.
asked me about it.
No, I didn't ask you about anything.
Yes, ma'am?
Correct.
Sorry, can you repeat that?
4750. See where Ms. Bredehoff asked you to describe for the jury what took place on May 21st. That follows? Okay.
Yes.
Now let's turn 48. Do you see that you're testifying and 725 seem to be different versions of the same picture to 2016?
If you remove the redacted metadata, you can find out. It's right there.
Or if you're telling the truth, you would know.
Recognize a part on a floor, and I'm supposed to know off the top of my head when you've
No.
lived through 5 years of this stuff? I don't think so. That's not how that works.
Okay. Thank you, Tom.
We approach.
Yes. Words or no phrases, no words, no sounds at all coming from you. If I hear one more sound, I will clear the gallery and we will continue this testimony without anybody in the courtroom. Understood? Good. All right, your next question.
Cross-examination last week, I showed you an audio where you told Mr. Depp to tell the jury, that would tell the world, that he's a victim of domestic abuse. Didn't you?
I said I find it hard to believe.
But he has told the world that he's your victim of.
And we signed a statement saying that neither party had ever said false claims for financial gain at the time. And he signed his name to it.
You didn't expect as many people to show up and testify on his behalf that did you?
Incorrect.
When you told this jury under oath.
And he signed his name to it.
You didn't expect as many people to show up and. Strike that. When you told this jury under oath that you punched Mr. Depp because you thought of.
I know how many people will come out of the woodwork to be in support of Johnny.
So you think Ms. Moss needs to come out of the woodwork to testify for Mr. Depp?
Everybody who was around in the aughts knew that rumor. I had heard that rumor from multiple people. Of course, that's what flashed through my head when my violent husband not only swung for me, but all of a sudden swung for my sister. Of course I thought of that. I'd show up or not expect her to show up. It didn't matter. It doesn't change what I believed at the time.
Depp was aggressive and trashed a trailer in Hicksville. You didn't expect the manager of the Hicksville property, Morgan Knight, to come forward and testify that that was untrue, did you?
Incorrect. I've already.
When you told this jury under oath that you had no idea that the paparazzi would be at the courthouse on May 27th, 2016, you didn't expect a TMZ employee to show up to testify that TMZ had been alerted exactly which side of your face to take a picture of. Did you?
How many people will come out in support of him and will fall to his power? I didn't hear your question.
You didn't hear my question?
Ms. Vasquez, if you do mind, please just repeat the question.
For a powerful man?
I have seen people do this time and time again.
Your tip was found exactly where he said it would be. Did you?
I have never heard Johnny testify. I've never heard Johnny claim that.
You didn't expect Keenan Wyatt.
Johnny has never actually said that.
Ms. Heard.
And
I think the jury can,
yes.
Ms. Heard, there's a longtime sound technician to show up and testify that Mr. Depp is not being fed lines through his earpieces.
His team treats him. Of course I expected that.
Okay, so you probably expected Isaac Baruch to come and testify for Mr. Depp, right? For Mr. Depp. After what you've put him through and so many others with your life. After what you've put him through and so many others.
Thank you, Your Honor. Ms. Heard, if Mr. Baruch felt misled.
Blame him from crying. This is horrible.
Ms. Vasquez has suggested that you faked bruises on your face. Is that true? Injury caused by Mr. Depp?
No.
Is any of the evidence of your injuries that has been confusion over when a picture of spilled wine?
There's so many pictures. There's so much evidence. For years, this has been going on, and I have pictures. We have text. We have everything. Normally, you don't get this amount of evidence. Crazy. It's easy to not know the context. I didn't photograph so much. I didn't have the presence.
Objection, non-responsive.
Emotionally?
Yes.
Psychologically?
Yes.
You individually.
Johnny promised me he would ruin me, that he'd ruin my career, he'd take my life from me, he'd make me think of him every single day. He promised me global humiliation. You saw those texts? Promised me global humiliation. Inviting a disgruntled employee over for a spot of purple to fix my flap, trying to block him.
Objection, Your Honor, lack of foundation.
Those things that you just testified to that Mr. Depp did, how did those resemble what happened?
She's overruled. What I see in this courtroom is an echo. This courtroom and the other courtroom he dragged to have me fired, blocking me to try to ruin my career, the threats, the whole world since our camera's here.
No further questions. Thank you so much, Amber.
All right, Ms. All right, ladies and gentlemen, you have heard all the evidence. All right, your next witness. All right, ladies and gentlemen, you have heard all the evidence you're going to hear in this matter at 9 a.m., and then the case will be submitted. I will tell you within reason back here Tuesday morning, at least again on Tuesday night, and if you have to go to Wednesday or Thursday, unless all of the jurors are in the room at the same time, doing outside research. A modified lunch recess just till 12:50. We'll come back at 12:50. We just have a few jury instructions left we have to do. All right, we'll see you at 12:50 then.
All right.
Okay. I already have them in a potential order, but let's go ahead. Is a corrupted file that we received from both of you. I guess it's corrupted on both of them. And nobody seems to be able to do anything about it.
Right.
So I think it must in evidence. However, it's not going to go back to the jury because it's corrupted. Okay, does everybody agree to that?
Yes, Your Honor. Thank you. It's
Okay.
just an Eastern Columbia building video, so that's fine.
That's just, yeah, just it's to give. Good. Let's get Jamie here. These, you want to get your list, Jamie, and make sure. All right, it's defendants 393, 57, 857A, 883, 1905. Make sure that's nothing. It's the second page of that. 1050. It seems to be a longer one. Hold on. All right, are you missing any other exhibits?
Your Honor, if I may approach.
Yes,
we
you have some?
from
Okay.
today.
All right, so these were the two. All right, so I have plaintiff's exhibit 1316 and 1317. Yeah.
I still need 1301.
1301, does anybody have 1301? 1301?
It was an Instagram post.
An Instagram post.
11A and 711B from today.
711A?
A.
Yes, 7,
I don't have those.
we just don't have them. 712 and 713A.
Understood, okay.
Can I get them now? Yeah. Trying to get all the exhibits together, all together, so we can review them.
And then the other one is 120D is not in evidence, but it's on their list as in evidence.
120D was listed as, you had it as an evidence, but we do not have it in evidence. All right. Excellent. That's good. Good. Okay, so we are very close to getting all of that. I don't want to leave here until we have every piece of evidence with Jamie and everybody has reviewed it, so we don't have to review that and waste time with that. Okay. All right. At the first one I'm going to go over is the direct, and I took those under advisement. Do you still have an objection to these two jury instructions?
Sure, Your Honor. So
these two jury instructions.
Sure, Your Honor. So I think the evidence, there's a connection with the UK litigation and with this litigation. There's evidence that he engaged with third parties in that capacity, that he met with the Daily Mail with Mr. Depp, and that all of that, I think, is relevant evidence to a self-defense, that Mr. Waldman made those statements in self-defense on behalf of Mr. Depp, if agency is found.
We believe they're inappropriate, Your Honor. First of all,
Defense, if agency is found.
we believe they're inappropriate, Your Honor. First of all, we have not been able to locate case law, but I know I had seen one a while
We said it was a
back.
reversible error.
Law as to whether it applies. And so at a minimum, I think we should figure that out, I guess. But the reason that we don't think it should apply is these were statements that are made by Mr. Waldman in 2020. I guess it was before Ms. Heard's counterclaim. So this lawsuit was a statement in response to the op-ed. Statements that were made a year and a half. So obviously both sides are going to argue defamatory implication and what is domestic abuse. To say that then it's fair for Mr. Waldman, a year and a half, things that he said in those statements, that's not fairly and reasonably. Ms. Heard responded fairly and reasonably here, but saying that if someone makes a statement in an op-ed, that then you can go and do whatever you want for 2 years, say whatever you want. And obviously there's only 3, but as the evidence has shown, it was part of a pattern by Mr. Waldman. It was, well, we don't believe it was either, but he had the opportunity to file a lawsuit in this court.
Right.
To have Mr. Waldman be his attack dog and to say anything Mr. Waldman fair and reasonable and entitled to the privilege is inappropriate. And I do think that before
It was a response to the op-ed, but I think there could be multiple statements in response to the op-ed, so I think that's not dispositive of anything in face. And whether that response was fair and reasonable is a jury question.
I don't, what do you say is the matter of law? The privilege of self-defense is a matter of law?
whether it applies.
Okay, I think I don't think it's a matter of law. I think it's whether or not if there is any evidence that a jury could find it being protected speech, not the weight of the evidence, but I don't think it's my role to weigh that evidence as far as how long it was made afterwards.
I think it is, Your Honor. I mean, it can't be the case. There's an alleged death. This is why this doesn't come up often, because this just isn't given. If it were appropriate here, every time there's a defamation case, this would be an instruction. Even the person who's the defendant in the case, who said, "Well, all I said, I was responding to something that was said before."
So all your evidence that you say goes to the jury are just the statements. That's why this should be given. That he made the statements. That's the only evidence.
Well, I think
she said.
Well, I think there's circumstances.
And that's
you have to make them. I have to have some evidence.
There to be a direct response.
Not the statements themselves, but is there anybody testify that he made these statements in response to her op-ed?
No.
Not that I'm aware of, Your Honor.
One small point there. There's no requirement that it be in response. Mr. Walden's evidence is clear, I think, that he was responding to allegations against Mr. Depp, and he believed
that he was responding to. So if it's not the op-ed, that he was responding to. So if it's not the op-ed, then we're a real
case. You take it as a separate case.
Okay.
So the standalone case doesn't. Your claim.
But he couldn't have made the statements as there's no. Plus, Your Honor, a couple points. Doesn't apply. And this is. Well, it doesn't. This is under the Haycox case, 1958. It doesn't apply if we. I could bring the case up if you want, Your Honor. It's so if the 12 Haycox versus Wilcox done, and that says. So the malice inquiry takes care of this. Allowed to answer any questions about this. So to say, well, he could have been making it in defense of something. They could have let him answer questions and get that evidence on the record. They can't say, well.
At your case, you're maybe it's not the op-ed.
But then there's no evidence of what that is. She was sued. She said 2016 when she made her and she has the op-ed that has a couple words that they're trying to turn into what we've just seen for the last 6 weeks, and then she responded to the lawsuit. Okay. So it can't be the case that herself in a lawsuit that was brought against you. If it's not the op-ed, then it's got to be her statements in the law veil themselves in the privilege.
Counsel for Ms. Hurd made a point of making clear that there was extensive allegations about Mr. Depp circulating. They were back to the context in which I believe these statements were made based on the date. It was very close in time to the UK action. They brought up the Dan Wooten article. These allegations date back to 2016. There's evidence, from which the jury could find that Mr. Walden was acting in defense.
That are in evidence.
Your Honor, there has been extensive evidence of the accusations against Mr. Depp. Extensive evidence of the accusations in evidence prior to the op-ed. I don't believe that's correct, Your Honor. It doesn't. Again, the number of allegations made by Ms. Hurd, it's been very well done. You have the People magazine article. You have the republication of her statements through the wife beater and the Dan Wooten issues.
Well, then would you agree that actual malice, you don't get the self-defense if there's actual malice in his statements? If the jury finds actual malice.
If the jury finds actual malice,
then it's not protected
that may
speech.
obviate the privilege, but that doesn't mean.
The only way they find defamatory statements in this case is if there's actual malice. And that's unique to this case, I understand that. But so if they find actual privilege.
And if there's no actual malice, they win.
Yes, correct. The same with this. That's why we're not giving a jury instruction on the slap defense, because there's no basis for it.
I mean, if the instruction
found out after we went down that legal road, we found out that was moot as well. Okay. So do you want me to deny? And 29. Okay. Put that in the deny stack. All right. Okay. So I see dueling paragraphs for the republication. Yes, sir. And I understand a republication And you just would rather have just the 3 sentences as yours for republication, is that correct?
Correct, Your Honor.
That didn't, well, you must find, or you want to add that into it? I'm not sure. I'm just not sure how I'm reading it.
And they just want the one sentence at the bottom.
That's
Okay,
correct.
that's correct.
Your Honor said that on page 92 of the transcript, I don't have a problem with the republished jury instruction. I just think it has to be accurate with adding the language, and that language sent to it may establish republication. So that's what we may establish republication. So now they're going backward.
Legal argument.
And if I may just make our argument for the record here, Your Honor.
Well, you did on Friday, but if you.
Which is a new audience, which is
What, and that's there.
What we propose, right, it's included in their instruction, and that is basically the full extent of our proposal committed to that.
Okay.
Lakova is a case that they've repeatedly cited in support of this republication issue, and that's a case where there was a defamatory New York Times article, that was a recent New York Times article, and the court said that that's not directed at a new audience. It's the same party tweeting to the same post article. So that, you know, Ms. Heard's audience.
The motion strike under advisement. Once I got it, there was more content to it, and that's why I'm putting it in. Would also add to it, though, is after you must determine whether any content that was added constitutes republication, and you must determine whether any added republication. You must determine whether any added content was intended.
Fine if that's the court's inclination.
Do you have any objection to that?
I'm thinking.
Let's see. All right, let me see if I can incorporate it into it. Okay, so merely linking to an article, you must determine whether any added content was intended to reach a new audience.
I think we would prefer just to say just that first sentence, merely linking to an article does not amount to republication, but adding content to an article content that was added constitutes a republication. I think it'd be better to just delete the last 2 sentences than to add the sentence at the end.
Is a requirement for republication. I mean, we've found a number of cases that when somebody repeats it to fit.
What do you want?
I prefer the court's language.
All right, then we're going to put my court's language. Okay.
Or
Sammy, can you do it? You gave him to Word format?
we did.
All right, can you do that here?
The only other thing I would note is I think the word retransmitted in the second line is misspelled.
Second line? Okay. All right, we'll take care of that. But adding content, just do it. Adding content, yeah, it's like this one right here. I'm going to add this instead. We'll take a look, okay? All right, and we'll clean it up and just take out the box. Okay, we'll get that done. So I think instruction FF, the plaintiff just has it as plain, which, I mean, it does say that it means you may not seize any word text.
The problem, Your Honor, is that redacted, so the statements are in isolation, that there's a risk at, so therefore there's no liability. We think because it's impossible to read those statements in the context of the whole piece. And so that's number one. The op-ed was all Amber's statements, not in evidence. So there's no point arguing about that other than you just have these one, instruction and say we cannot read it as a whole, so therefore we can't.
If there's anything there's a lot of instructions here. I don't think there's anything that would indicate they can't find a liability if they're not able to take just thought it would be more appropriately phrased to be mutual as opposed to obviously applying only to one party.
Well, because yours says you must read the statements. Also can take the content in the context as a whole, but you can take the context of the op-ed, their claim, and then for your claim, we can determine whether any of the statements, that way they can't just pull out, because it's accurate law also, that they just can't pull out the word hoax and say, okay, this whole statement.
Agreed.
Okay?
That's fine. Thanks.
That's fine in concept. I guess I would ask if Your Honor does that to add a clause saying
statements in context as a whole.
Right. So, but I think it's defamatory. You must read the text of those statements as a whole. Text of those statements in context as a whole or something.
Well, that's kind of, you must read this.
You must read, can we say you must read those statements in context as a whole?
You must read those
because I just don't want them to think that it's impossible for them to.
Any problem. Okay. In determining whether any of the statements attributed to Mr. Waldman are false or indeficient. Does that sound correct?
Yes.
All right, we'll add that as a second paragraph. Keep Sammy busy. All right, the next one I have, is,
32.
oh, I'm sorry, it's Depp 32.
This is the new one.
Do you have any objection?
We do. Yeah.
Okay.
The objections made by counsel during the course of trial, what inference to draw from Mr. Waldman's instructions not to answer?
Well,
And
what inferences from the fact that objection was made?
yeah, but saying sometimes attorneys stated objections during the course of this trial and instructed a witness. No.
Right.
And objections and instructions to witnesses are not evidence, and you may not consider them in reaching your verdict, nor are you to draw any. So,
Well, because to be fair, in the depositions you wanted to keep in all those objections. We usually would take them out, but you wanted to keep them in. So I want to make sure the jury doesn't have any improper inference at leaving those objections in. You wanted to leave them in because show that, hey, I asked the questions, they weren't answered, fine. But you can't infer from that, oh, well, they're hiding something then, or it's attorney-client.
or when someone takes the fifth in a criminal case, I get that.
Right, which
but,
I would give an instruction for.
Of course, I know, I understand that, but I think that the jury is entitled to draw their own conclusions and not inferences. They're not entitled to infer anything from that. But I just think that this risks confusing the jury and getting the jury. If they stand up in closing and say they haven't presented any evidence that Mr. Waldman was doing this, then that's using this instruction as a sword. They haven't. Do you understand what I'm saying? They haven't proven that Mr. Waldman was acting as his attorney. They haven't proven that Mr. Waldman was authorized to make the statements. Then they rely on this to hide. And we're not allowed, and I'm not saying that we will, but I'm not going to say you heard him instruct him not to answer, and you should infer that he was acting as his agent. I know I'm not going to say that, but if they're the converse of that, then that's prejudicial, and makes this inappropriate.
All right, yes, sir, Mr.
Your Honor,
Ramos.
this is just an accurate statement of law. They chose to play about 30 minutes, instructed not to answer. Without this instruction, that's prejudicial.
All right.
And it would also be prejudicial if they're in a Depp's relationship.
That doesn't follow from this instruction.
It does.
This instruction is simply saying that the jury is not to draw any inferences from the objections and instructions inserted. Consider the evidence. They could consider whether evidence was presented or not. The instructions and objections are irrelevant to that question.
No.
All right, I understand your phrasing of the law, and I want to make sure that the inferences aren't taken.
Can you deny it over our objection?
You got it. No, I can correct it over your objection.
Sorry.
Good, Freudian slip.
I meant grants. Yes, sorry.
Okay.
Can we get the arguments that they're allowed to make on closing on that, Your Honor? Because I don't think that that's appropriate for them to point to a lack of evidence when they didn't allow Mr. Waldman to testify.
Pointing out that instructions there's no connection here between these issues, Your Honor.
No, I'm not going to do that. So we're going to do Depp 32. I just need to clean up the top part of it. All right. Over objection. Be offered. All right. Then I have instruction JG, which is the model.
Right.
So why would I not give the model?
We believe you should. I think the only substantial difference is that rather than saying, as it's written, it says clear and convincing evidence that Mr. Waldman's statements, it's confusing and misleading to say that if you found by Waldman's statements were made by Mr. Depp, we already have a principal agent instruction.
Right. If they find principal or agent, I mean, that would be the only basis for it.
Well, first of all, if liability is entirely vicarious, which I think is the position of the counterclaim plaintiff in this case, I don't think there's any evidence. If liability is entirely, punitive damages are only applied where the person against which punitive damages are being assessed actually engaged in conduct that was wrongful, the way they've pled and sought to prove their case. I think that's the first.
So they're saying you're not entitled to a punitive damages instruction.
Well, I disagree with that. There's no case law that they've cited in here on that, and I think that's going backwards. That's an argument that we've already, and I just think that Mr. Waldman's statements were made by Mr. Depp. I'd be okay with something that said that Mr. Waldman, while acting as an agent for Mr. Depp, made statements with knowledge. I'd be okay with that.
Is that okay?
I think we would on the basis previously asserted, Your Honor, and then what's the other? I'm sorry, could I have counsel's language again one more time?
Sure.
Yeah, if you have found by clear and convincing evidence that Mr. Waldman, comma, while acting as an agent for Mr. Depp, comma, made the statement that they were false or so recklessly, I think it's so reckless. There's a typo there, sorry. We'd be okay with that.
Maintain the same objection, Your Honor, the principal liability, and we do have case law for
Charge of that one. Okay. All right. That's fine. I think that was it, correct, as far as...
Other than the verdict form.
Perfect. Let's go to the verdict.
Verdict form.
Perfect. Let's go to the verdict form. All right, let me get the verdict form. All right, I think with the verdict form, just the first page. Am I correct with that?
In the punitive damages.
And the bonds, right? Do we have?
I think there was a comment in what we got from them that we changed.
All right. Well, in the put here. Oh, thank you. All right. It was about Mr. Depp. I think the plaintiff wanted that out because we already have the statement has a defamatory implication about Mr. Depp, and the
If you look at the, I think it should track the finding instruction, which is jury instruction C on page 4 of the jury instruction form does.
Okay, let me take a look. And that was C? Okay.
Yep.
Okay.
So the way it's been written tracks the finding.
All right.
Don't have a strong objection here, Your Honor. I thought it was maybe cumulative, but
it does match the finding instruction, which would be clear to the jury. So we'll keep that in.
That's fine.
And then the punitive.
And so that would carry through to all of the.
Oh, you withdrew all those?
Yeah. We'll withdraw that, Your Honor. Their proposed language is fine.
All right. So the verdict forms as written are the verdict forms good to go, correct?
I'm sorry. Did they withdraw the punitive damages? Okay. Sorry.
So we're good with the verdict forms. What I have is the verdict forms, correct?
Your Honor, I do just want to make sure, and I understand we don't go back, but I just want to make sure that for the record, we do maintain that the verdict form should state that the defamatory implication was false, statement was false, because under the Pendleton case, that can, a facially true statement can still have a false defamatory implication.
And I think we had that on the record on Friday, but thanks for putting it again. It's fine. All right, so we'll keep the verdict forms. Did you print out the other? No, you can print it out. That's how, yeah. So which ones are we missing then? We're missing which jury instructions? You're working on 2 of them, right?
32. I have 32 in FF right now.
32 in FF. And for me, right?
Yes, they're editing it right now. It's JJ.
Okay, JJ is coming in. And did you do the other one yet or no? That one here. Could you guys do... Michelle, could you, on Depp 32, could you take off disputed and send that to us too?
Yes.
And that would just leave us, we'll get those 2 printed out, and then I'll tell you the order that I'm going to do them. While I'm doing that, I do have the laptop. Look at the jury evidence on these. It'll stay up here at the bench, but all we did was files on here. There's no password for it. As soon as you open up, it doesn't have any internet, and there's just 2 files. One's plaintiff, one's defendant. They just click on those 2, and then they can watch all the audio. So if you want to take a look and make sure it's been downloaded to everything that we put on our website, which is all the evidence. We didn't receive any new evidence today for audio or video files, so that it's everything on. Take a look and make sure that everything is there. You can do that. Also, all the...
Yes, if I may approach, I have 1301.
Okay.
And then, Your Honor, I just.
Sure.
I understand that Defendant's Exhibit 712 and Defendant's Exhibit 713 were initially moved into evidence in redacted format.
Correct.
Today, we offered them and put them in an unredacted form, so that's the
712A and 713A. Yeah.
I believe Your Honor should already have those in unredacted form. I believe that's how they were provided to you all.
Oh, they're in our binders down here?
I believe so. I will. Yes, so I believe those, you should actually have those in unredacted form from defendants.
All right, defendants. We have a few
I think they would be in the binders, that's correct.
712 and 713. Those. Yes.
So I can give you copies. I was gonna make a proffer for the ones that.
Do you want to go ahead and make a proffer?
But it included 712 and 713, so I can give you copies of that.
Oh, you can? Well, that would make Jamie happy since she's down here digging through binders.
Right. So I can give you copies of that right now.
Now we have those in evidence. Okay. So are we missing any more from over here? Or did you find out about the one that you thought was in evidence?
So, Your Honor, defendant, I believe, it's Plaintiff's Exhibit 1. Actually, Sammy and I had a number of back and forths about this exhibit. I believe that Defendant's Counsel provided a redacted version of that exhibit to the court. Our reading of the transcript, that exhibit was not actually offered into evidence.
Okay, so it's not in evidence then.
Not evidence, Your Honor. I thought, and I believe I emailed it last week.
You got to take disputed off.
If you don't have it, I'm happy to bring it tomorrow. But
Okay, all right. So I just want to make sure because it was checked off on somebody's list that it was in evidence, and I just want to make sure. I don't know, but it's not. We're good.
And then I hope it's 711A and B. I'm not sure.
No, I think
Is that
711 was
wasn't
wrong. It was 712 and 713. So we're good.
All right.
So Jamie, are we missing anything else? Sammy, did you print out the ones that they sent you? The email. Did you email Sammy the?
He's just double checking right now.
Oh, okay. We'll get that in a second. Let me just put these in the order. Get that one without dispute on it. Okay, sure. Republication.
Do you still want this last paragraph to be before you get
It was in the one that I gave you. Let me see. Yeah, that stays in. Yeah, that stays in. You want to go ahead and print that out? Yeah. All right. Just print out 2 copies so we can share them. The one that Sammy printed off on republication, I'm just going to give you a copy so make sure. Right, okay?
Yes, and you should receive in your email soon FFJJ and 32.
Okay. So if you print those out too, Sammy. Out. So you're sending FF also? Mm-hmm. Okay. Thank you. All right, let me just get this printed. Could you print me out another one of AA? There's a mark on this one. Or at least email it to Sammy. Something in the paper, and it just doesn't look right. Printing? Huh? I'm sorry. Can you send it to?
An electronic copy from the court?
All I have is a paper print.
Okay, so we can scan it.
You can scan
okay,
it and
that's fine.
if you want to do electronic, that's fine.
And then will these be posted on the?
Until after I get
Not till
them.
after. Okay, wasn't sure. And then they're read before closing.
They're read
so-
before closing. All right. So we have
Thank you.
FF.
Okay, so I guess we just replace.
Thank you.
Oh, okay.
If you want to take a look at that instruction, and make sure it looks okay before I add it to the stack. When was that sent to you? Michelle, you sent the actual malice one?
Yes.
Okay. Oh, never mind. Jamie already gave it to you. Sorry, Jamie.
And Your Honor, was it?
Is there?
No, I think it's fine. Does the court want to leave the heard 7
No.
sort of things in there? Because otherwise we could.
Oh no. Well, yeah. The numbers at top can stay. I just don't want to say disputed.
No, I don't think. Okay.
The heading. That's better for the record if we keep it that way. Okay. So, are you still reading the publication? Okay.
Sorry to bother, Sammy. Could we get one more printout of the actual malice instruction?
Sure.
Thank you.
Jamie, can we get another actual malice?
AA. So these are only copies.
All right. Any objection to the republication then, as typed?
No, Your Honor.
Okay. Put that in there as well.
Hold on.
Is there a typo?
Nope.
Right.
Your Honor, I just have a very quick question regarding closing arguments, if we may. Does the court have any objection to very small clips of...
As long as they're in evidence, you can play anything, show any picture.
Well, that's my question. So obviously depositions were by video, many witnesses, especially from into us playing video depositions, portions of...
If it's not in evidence, it doesn't get...
No, of course, just what's in evidence.
But there's no video depositions in evidence.
Oh, I see what you mean. So...
The only thing that can be played to them is what is in evidence.
But their testimony, it's witness testimony.
Well, yeah, but depositions are witness testimony that you have during trial that has evidence. And video depositions are the same. That would give more weight to video depositions than witness testimony.
So my question is a follow-up question to that. Obviously, there are videos of witnesses testifying.
No, none of that comes in.
Okay.
The four walls of this courtroom is what the jury decides this case in.
So we don't have a problem tomorrow. Also, we can't put in front of the jury written deposition or trial testimony.
That's correct.
Understood.
Only things that are in evidence.
Understood,
But you
Your
can
Honor.
show pictures in evidence, you can show video
that's in
or
evidence?
audio that's in evidence.
Okay.
All of that's fair game.
But
You
no display of written transcripts either.
No written transcripts, just only items in evidence. And
No,
I just want to make sure.
Thank you, Your Honor, for that clarification.
And you have 2 hours, right?
Right.
2 hours each. I made a circle. Okay, so I made a circle. Okay, so let's go ahead. Let me just go ahead and read into the record the order that I'm going to give the jury instructions. I'll also read into the record the instructions, and I will read the instructions that were withdrawn, just so we have a complete record, okay? All right. Here we go. All right, so for the jury instructions, number heard I, number 3, number 10, 1, B, 1, B as in boy, E as in Charlie, D as in Delta, E as in Echo, F, G, 13, Y, F, 15, Y, F, A, B, D, T, C, 20, U, V as in Victor, U, V as in Victor, K, L, 5, 2, 8, 9, 16, I. All right, those are the ones that will be read to the jury in that order. Okay, 3 in that order. Okay, the ones that were denied was instruction 22, 23, or CC, NN, both as in Nancy, OO, PP, RR, S as in Sam, SS, 28 and 29 were the ones that were denied. For the record was instruction A, 2, 4, 11, 14, 15, 17, 19, 21, 26, 27, X as an X-ray, 31, W, EE, GG, Q, DDD, Q, 18, J, M, N, O, P, S, HH, LL, UU, VV, WW, XX, ZZ, AAA, and BBB. All right. we will copies now. I'll get you hand copies of the jury instructions I'm going to read in that order, so you'll have copies when you leave here, okay? And I'll give you copies of the verdict form as well, and you can have those for your closing arguments. Other than that, if you could come up to see Jamie after I leave the bench just to make sure you go through the exhibits and everybody okays the exhibits, so we don't have to do that tomorrow. And also if you can have a look, sure all your exhibits are there that are going to go back to the jury, okay?
Your Honor, one quick question
Okay.
about closing to make sure
Sure.
we don't have any issues tomorrow. Understand he only sees evidence
Yes.
that they've seen in the trial. If that evidence is displayed through like in the trial, if that evidence is displayed through like a PowerPoint or whatever, are headings allowed, or do you not want to see any written text or anything other than just evidence?
I mean, I've seen PowerPoints in cases before in med mals where they have their other particular case. I'd rather just have no writing and just have your arguments orally.
That's fine. I just wanted to, make
Okay.
sure that there wasn't
Just try to keep it clean.
or paraphrasing of witnesses or anything like
Okay.
that.
Fine with everybody. Does anybody?
That's fine with me.
That's a good question, though. Are you going to have a PowerPoint?
Probably with evidence.
Okay.
You know.
Did you want me to have the big screen up as well for the PowerPoint?
I think so. Yeah, I think that would be.
Okay,
Thank
good.
you.
We'll do that as well.
And starts at 9.
Starts at 9. Closings start at 9.
So, Your Honor, Mr. Nadelhaft has a proffer.
Yes,
Says,
okay.
do you want to do that now before we?
Sure.
As does Ms.
Everybody
Myers.
wants to hear your preference.
As does Ms. Myers at the end of Mr. Nadelhoff's.
Yeah, okay. All right. No problem. Or the court reporter can hear you.
This will be shorter than the other day.
Oh, good.
Okay. This is for metadata. On May 16th and May 17th, attempted to introduce into evidence photographs from May 21st, 2016 that included metadata on the photographs. Ms. Hurd testified that the metadata was included on the photos by pressing a button on her phone. The metadata pictures were taken on May 21st, 2016, along with the times they were taken. The exhibits were defendants' exhibits 700 through 726, and our exhibits A through the proffer. Tabs N and O of the proffer are now blank, as defendants 712 and 713 were admitted with the metadata on May 26th. Mr. Depp objected to the metadata on the document, stating that the metadata was hearsay and there was no foundation for the hearsay. The court sustained the objection on the ground that the metadata was hearsay and that there was no foundation. The exhibits, but redacted the metadata. And then separately, we have a proffer for Stephen Duders on May 20th to designate certain portions of the deposition testimony for trial of Stephen Duders, who was Mr. Depp's personal assistant. Mr. Duders testified that he was on the Boston flight and sat in a seat facing. He further testified that the day after the flight, Mr. Depp told him he wanted to, quote, smooth whatever issue, end quote, existed with Ms. Hurd. Mr. Depp asked Mr. Duders to, quote, write a text, end quote, whatever she needs to hear, end quote. Mr. Duders then sent a text message to Ms. Hurd about Mr. Depp stating, quote, when I told him he kicked you, he cried, end quote. The testimony, Exhibit A, Mr. Duders' deposition. Ms. Hurd moved to admit the text message into evidence, arguing it was not hearsay under Rule 2:803, which provides for the admission of statements of a party opponent, and it argued Mr. Duders was acting as Mr. Depp's agent when he sent the text, therefore not hearsay. The text message is exhibiting that although Mr. Duders was Mr. Depp's employee, sending text messages to Ms. Hurd was not within the scope of the employment. The court denied the motion for Depp's agent when he sent the text message, and I have copies. Employee sending text messages to send the text message, and I have copies to provide.
All right, fine. We can add it to
The list. Yeah.
We have a box for you.
Oops.
All right,
No,
we will
here's this.
add that.
Oh, sorry, Eric.
I think he has more.
And this is the other one.
All right, we'll make them part of the record. Thank you, sir.
Thank
All
you.
right, yes, Ms. Myers?
On May 25th, 2022, plaintiff intended to call Dr. Kim Collins as an expert witness in forensics pathology. Defendants objected on the basis that designated as a defensive witness and was designated only to rebut Dr. Jordan, which was defendant's forensic pathologist who had not up at this trial. Dr. Collins intended to testify as to whether Ms. Hurd's descriptions of violence and injury was allegedly sustained by Mr. Dent with the photographic evidence at issue in this trial. She also, for incidents where there was no photographic evidence, she would have testified as to what injury she would have expected the violence that Ms. Heard testified to. And finally, she would have testified as to her opinion as to the finger injury and what she observed, consistent, which was similar to what Dr. Gilbert testified to today.
All right, thank you. Any other proffers? Okay. I'll leave here until you check the laptop and you check all your evidence and make sure we get your checkbox on that and everybody's happy with it, okay? Anything else for the court?
Thank you.
Really?
No, thank
you.
Thank you, Your Honor.
We'll see you in the morning.
All right.